Live.
All right, welcome to the House Judiciary Committee this Wednesday morning, April 16th, and we're going to be taking up S-109. We have a somewhat different seating arrangements. Folks noticed at the table here, we have Tom Oliver. And the reason for that is Coach Kevin Christie, Representative Christie, will be joining us after being out for a while, but he will be in a wheelchair, and he really needs to sit at the end of the table because otherwise it'd be hard to maneuver. He remains our ranking member. We haven't been promoted. Maybe demoted having to sit next to me.
I think so. There's no place to plug anything in.
Any event, so we are looking at, and I think I've lost my, here we are. 109, and we're going to start with Jennifer. Thank you for being here, Jennifer. And we're looking specifically at sections 31 and 32, I believe. Is that? And this is in draft number 1.1. Well, let me actually, yeah.
That's what I'm looking at.
Okay. Okay. Over to you.
Good morning. For the record, my name is Jennifer Pullman. I'm the director of the Vermont Center for Crime Victim Services. And I thank you for your time today on the provisions relative to S-109 that speak to victim notification, section 31 and 32. If I may, I did post something to the committee page, but I would like to send this article around in case you haven't seen it. The picture will be familiar to you. This is one of those documents that I provide that I will not be offended at all if you read it entirely while I'm speaking, because it really provides some context for this committee about why you see these pieces in front of you that are in the miscellaneous judiciary bill. And I'm going to take a chance here. I'm going to voice or give voice to something that you generally don't want to give voice to, but I'm going to try. This is truly simple and truly non-controversial. So I've said it, and we'll see how this goes.
Let's go ahead anyway. We'll try.
As far as, again, I think it's important to provide some context, especially for newer members. But really where this focus on victim notification started to get some airtime, I would say, is back when we talked about earn time. Some of you may remember that conversation dating back to 2020 and then revisited in 2021. And what really spurred this interest was the thought that we were going to now be changing sentences moving forward, where somebody could earn 7 days off per month for not committing a major infraction while they were incarcerated. And we started to look at what is provided for victim notification. We want to make sure that victims know upfront and throughout what they are looking at for a release date for the person who harmed them. And the thought that committees walked away with was that we had a system that would adequately address that victims could get that information if they so chose in a timely manner. This was revisited last January when there was a bill that was brought forward in House Corrections and Institutions regarding learn time, which proposed to add an additional calculation where someone could earn time off their sentence if they participated in educational programming, whether they were incarcerated or on parole. And what the center identified for that committee at the time was that what you thought was happening for victims in terms of notification was not actually happening, and that victims could not opt into a system where they were getting notification if they chose of that release information. And the chair at the time, and then the chair of Senate Judiciary said, wait a minute, before we even go down the road further of thinking about how we do additional reforms, we need to take a look at this system, and we need to make sure that it is working in the way that we believed it could work for victims and survivors. Thus, you saw in Act 159, there was language included that would require that there was a report back to Joint Justice Oversight. I know the chair has been involved in that and has heard those conversations, wherein the entity's name were the Department of State's Attorneys and Sheriffs. the Department of Corrections, and the Center for Crime Victim Services and victim survivors of crime, all of whom testified before joint justice last session. So this, again, is an issue that has been vetted, even though it might be brand new to some of you. It's been vetted, again, back January before Senate and Judiciary and House Corrections and Institutions, and then also before joint justice. At the time, then, Joint Justice said we need to do more work, and Chair Emmons took this on in her committee. So there have been multiple days of testimony on this issue. So there is context. There has been quite a bit of airtime, and currently there's a plan for that group and other stakeholders to meet in May. Some of the concerns that were raised, and I don't think there's any disagreement, which is why I say this is simple. Concerns that were raised and identified, and I know that the Department of Corrections is already working with the vendor to begin some progress on those issues. But one was that there really isn't currently this menu of options for victim survivors to choose from. So we all know that victim survivors are not a monolith. Some just would prefer no information at all, and others want every single piece of information. It's a safety issue for some. It's just just clarity, that transparency to know what is happening with this person. And so giving them that menu of options had at one point in time, as I understand, been an option, but it was then decided that it shouldn't exist for whatever reason. I think there was concern that it was providing additional trauma to individuals, because certainly that is the case when you're getting that information and you're working. I get that, because when bills come through this body, I have to make those calls to survivors as well to let them know that this is happening, because they chose to know. They made that choice, and they told me, no, this is upsetting, but I want to know. So what we all agreed upon is that we want to bring that back. We want to bring that option back. And that, again, that work, as I understand it, it's already begun. And I think that's really important. Some other pieces that were raised that were of concern were a lack of accessibility, whether it be language access or just simply readability of some of this information. Some of the pieces that I saw were really high level. It was really challenging for me to get through even a paragraph and to think about how we can, have a survivor lens on everything that goes out from our departments to make sure that it's readable, accessible, and it's in languages that reflect what is the dominant ones in Vermont for non-English speaking people. Currently, the only language offered was Spanish, and actually it doesn't reflect the top 10 languages that are most prominent for non-English speakers. So again, that work is being done, as I understand it. We talked about, and we have spoken about in testimony, that sometimes notifications go out and they are for the wrong information. So a survivor might think that somebody's being released, but they're actually just being transferred. That, you can imagine, to get that on a Friday is devastating. And what that does to re-traumatize somebody to only then later find out they were just transferred. So again, I think this is something that I understand the department is working on as well. And just the notifications themselves, they're fairly generic, impersonal. I hear from victims and I hear from advocates who've signed up for notifications of the system that they're blank. Sometimes they're for other offenders not pertaining to that case. They don't identify the case. They don't even identify the victim. So again, these are pieces that were brought forward in House Corrections Institutions and Senate Judiciary, and then in Joint Justice Legislative Oversight. So they're nothing new to the chair, but they are new to this committee. They kind of traveled outside of your jurisdiction somehow. And again, the bottom line was, when I was hearing from survivors, the thing that stuck with me is that one survivor said it really requires a savvy victim to negotiate this system and to have those resources. And so this conversation, as I've alluded to, is finally happening. And it's because this body has elevated the conversation into a priority point for the agencies and entities involved. And the work group has yet to meet. And hence the language, and I'm going to jump to section 32, if that's okay, go out of order, because I did listen to Eric's walkthrough, and I'm here to tell you again, this is a simple concept. And while we are on page 25, it starts and substantively on 26. It was important to the center to make sure that the momentum that we have thus far is not lost. It is because, again, this body has chosen to elevate this to a priority that people are taking a look at it. And we speak about reforms all the time. And just next door in house corrections in institutions right now, they're talking about second look legislation. It is really important we get this right before we continue to go down a path of additional changes to laws post-conviction. It is really important we get this right. And why I thought this was an important vehicle, meaning S109, was that there was no other way to start this conversation and have it passed, frankly, this session, other than to think about, again, what I consider, I'm biased, but what I consider a technical change in terms of establishing this work group. As far as the cost, I did follow up with an email to all of you after listening to Attorney Fitzpatrick. The center has our advisory council. You have met some of them. Two of them have testified before Joint Justice Oversight. They are the two members who want to continue on in this role. The center provides stipends for our victim survivors. We consider them experts. We consider their lived experience to be valuable. So this would be at no cost at all. There would be no reason why we see this provision would cause this bill to go to appropriations. That would be absorbed by the center, and it is a value that we hold, that we honor their contributions. So with regards to that concern, I want to assure the committee that that was not a piece of language that we had suggested, and the center will be providing stipends as we do for all of their work the valuable work that they do.
So on that issue, then we could probably strike subdivision G on page 27, like talks about compensation.
Yes, absolutely.
You may still, this bill still will probably go to appropriations, because whenever there's a work group, whether or not we've said there's compensation, they like to hear that. So just FYI, when we have any kind of working group or task force, they look at it to confirm that there's not a cost for that much. So,
Well, I can assure you my testimony would only be about 1 minute on that provision.
Yeah.
Again, that's a value the center holds. And again, I do feel it is very important that we do formalize some sort of a group to move forward, because I don't feel that we'll continue on where we are. And then you're going to hear me complaining every time we have another reform post-conviction that our victim notification system is not working in the way that you would like it to work.
and also I would think that we can remove the meet not more than 6 times, which is also attached to the appropriations component.
Yes, I heard there was discussion about that, and I don't feel that there's a need to do that, again, because there's no appropriation needed for this group. And I would love to think about this being something that just becomes more organic, where the conversations are happening, those relationships are being built or being strengthened, and that we're doing this because I believe everybody. That's why I believe this is really simple. Everybody has their eye on the goal. It's just a matter of making sure that we don't lose sight of the finish line in terms of all the competing pressures on folks that are doing this work with limited resources to be in that moment of reacting versus taking this opportunity to be proactive.
So you're saying we don't have to legislate, you guys having a conversation?
I think you do. No, I think you do.
Oh,
I
okay.
think you do. And but I fear that, and I understand from my colleagues that I work with closely, there's so much reaction in our work because the resources are so short that sometimes it's hard to be proactive. And also sometimes you work within an agency that this might not be the number one priority. So we need you. We absolutely need you, but we just don't need any money.
For this.
Yes. I mean, yes, for this.
Right, yeah.
Barbara and Angela.
Thank you. I'm trying to remember if this has come up or not, and I don't remember. So does the current software system that the state has have the capability to do what you believe needs to happen in order to have an adequate or a successful victim notification process?
As I understand it, and Director Pelkey will speak to this, and I've been invited to, I was invited to a meeting with the Vines folks and also with DOC. There is that capability to do this. It's really building it out to be able to do that. So whether there are additional resources that are needed, I think that's going to be a part of this conversation. But again, it was there at one point. And so it's, again, identifying the issue and then as a part of this conversation, are there additional resources that are needed? I don't know that, but I do know that I've been made to understand from the Vines vendor that they can do these pieces. And in fact, they could actually go across the whole spectrum notification from pre-charge to post-conviction. So that's something that is worth considering.
And it's interesting because I had a constituent meeting last month and I had a constituent who raised the inadequacies with our victim notification system. And that's the first time I've sort of heard it from a non-student constituent. I mean, certainly related to sexual assault, that comes up a lot, but this person had moved here from North Carolina and Senator Gulick was in this meeting with me. And she had said, you've got to look what North Carolina is doing for victims because we knew everything that was happening and it was very supportive. And so I've looked to see what North Carolina is doing. And they do have a victim. I mean, they have all the other protections in place, including, I can't remember if they're using Vines or there's one other one. There's like a national, I can't remember the name of
Hear
it.
from Director Pelkey as a question that's
Yeah.
directed towards her, but Vines is the primary one.
Okay.
And Anna Nassett, who testified before you, she was the victim of stalking and is the victim of stalking. She, that was in Washington State, and she had a very different experience of the Vine system in Washington State. And then Kelsey Rice did here in Washington, here in Vermont, and you'll see that in the article. So there is that capability. I believe in the system. I just believe that I believe that this feedback will be very helpful. I believe that there's commitment from all parties.
And
Towards that.
do you think that any of that commitment needs to be tighter in belts and suspenders in legislation so that it's not informal or formal agreements and it's not like embedded in our law?
My thought that you see before you is that we would have this task group with an official report back date to Joint Justice, because I think that would determine if we need additional language. I'm optimistic that I don't think we do. I'm thinking that we will figure this all out. But I think that report back for me was really, really critical to make sure that people are really, doing that dive into the work.
Well, Angela, then Tom.
My question is a follow-up, I guess, from the chair's point about deleting the task force shall not meet more than 6 times. Do you think we should keep line 15, the task force shall cease to exist on February 15th, 2026?
I'm thinking about that. I could go either way on that, to be quite honest. I'd like to think that we could accomplish our objectives that were identified by then. I'm sensitive to the fact that we may not.
Yeah,
And-
and sort of, I would feel more comfortable that my, yeah, but it seems odd to me actually to declare an end date if we are not limiting the number of meetings. I
Actually-
understand why, I guess.
Yeah, actually, we need to have some sort of end date. And whenever we have a task force or working group, this also will probably, now I'm remembering, GovOps very briefly. And if we don't have an end date, they will say you need to have an end date. So we can change that if we want to have July 1st of 2026, just to give a little extra time, but we do need an end date.
How about July 1st then of 2026?
How many?
There. I'm, while we're talking about victim identification, I'm just thinking, part that I don't see in here would be, rearrangement. How's that going these days? Are they falling through the cracks? For court, I mean, is that something that also needs to be considered, and do we have the right people to cover that topic if they need to be on this task force?
One of the suggestions I was going to offer was that if I know the network had asked to be included, and I know that Attorney Paul had asked to be consulted with. I understand why, even though it is about victim notification. But I think what's missing here, and this came up in House Corrections and Institutions, is somebody from law enforcement. And I would suggest that we have the Victim Services Director from the Vermont State Police. She also was with the Attorney General's office for 20 years. She gets this information, and that is a concern because that happened in Kelsey's case. And how we are providing training holistically to everyone across the board in terms of entering this data. So I think having a law enforcement representative would be appropriate, and I think that would be the position that would best represent.
I think in my experience, there's a very high likelihood between the law enforcement and corrections line is where it's really easy to drop that ball.
Well, I did take the liberty in advance of my testimony of speaking with the current director, and she would be very honored to be a part of the conversations moving forward. Thank you for the question.
Ian?
I was just wondering, I don't know if we've actually had an explanation on what Vines is, like, or.
I'm going to punt
Okay.
that to the director.
Okay. Great. And then, okay, then I'll hold my.
Yeah, more on this 32, and you want to jump back to 30?
No, I'm good on 32. If there's no more questions on that, please. Again, I do just want to underscore, I know it probably sounds awkward, building off your question to legislate conversation, but I think it does, again, elevate this to a priority. And I think it's important that we solve this before we continue to go down the road of looking at other potential changes. And I think that there's an opportunity for the system, building it out, that it could work really well in other areas, not just post-conviction. With respect to 31, again, still going down the non-controversial simple hill, the change to earn time, and this conversation started to occur back in joint justice oversight. We were looking at notification, doing a deeper dive, and realizing that when it comes to notification of earned time in 28 VSA 818, the department has an affirmative obligation to provide notification no less than 90 days to an offender of what time that they have earned, wherein the statute only requires access to victims of crime to have this access to this information. So again, this gets me back to that savvy victim comment that was shared with me by a survivor. So it's true that information is accessible on a database that lives in Kentucky, and victims can go on the computer and find that information. But what started in joint justice was, why wouldn't we also provide that same level of affirmative obligation to letting victims and survivors who choose to know how much time the offender has earned their minimum release date? And what I think is really important, and I had this conversation with DOC and the Vines folks, is, do we build that into the system, or do we really encourage that personal connection? Because what victim advocates do can never, ever be substituted for by a computer system. And this information for victims who choose it is going to come with a lot of questions, is going to be a trigger, but they're choosing that. And in speaking with Director Pelkey, their unit said, let's give it a try. We're already collecting this information. We're collecting it for offenders. Let's give it a try and make sure that we are picking up the phone. We want to keep that relationship, picking up the phone and making those calls. And the determination was that we don't know how often it's going to be used or chosen by a victim survivor, but we think we can take this work on. And if not, we will be back next year. That's part of that task force. But I think it's really important to make sure that, again, we're supporting the relationship between the victim survivor and the advocate that works with them. And we're making that personal connection about information that is so incredibly important for their safety planning, for their peace of mind. Always remember what I heard from Joanne and Ned Winterbottom, the parents of Laura Winterbottom, who was brutally killed in Chittenden County back in 2006. They said that, when we had his sentence, when it was 35 years, they agreed to it because they didn't want to go through the trial. That gave us peace of mind to know that we had 35 years to just focus on our grief, our healing, and our daughter's memory. And so for some victims, it's just important to know what that time frame is. And I want to make sure that we honor that. And this was, again, agreed to language with the Department of Corrections. And I think that this makes sense. It's important to, again, make sure that what we're doing for folks who are earning the time, we are also letting victims and survivors know what that time frame is. And we're doing it in a personal manner versus expecting somebody to find a computer, find internet access, and look that up and receive that in a vacuum. So that is our the second proposal that we had put forward. So again, I don't know if there are any questions on that piece, but.
Sure.
So just the piece that you just said of that it is, you didn't say in person, but I think you said
Picking
a
up
personal.
a phone or,
Yeah.
just a reach out.
Is that is not included in here? Like, I feel like it still could be a Vines notification. And you feel like it's clear enough in this
I think
language?
it's clear enough,
Okay.
and Director Pelkey can speak more to that, but I
Okay.
think the decision was not to necessarily build it into the automated module, but that this would be something that, they were going to essentially, as I understand it, pilot and see how this would work and see if it's worth even spending that money to go down the automated.
Okay.
Other questions? Did you have anything else?
No, I'm going to walk away with my simple proposals and non-controversial and hope that is how it sticks.
And our Corrections and Institutions Committee loves this as well.
Yes, I had.
To make sure this is run by.
Oh, they've heard about it quite a bit, and I have 3 volunteers on that committee who can't stop grabbing me for conversation. So they're very excited about this.
Great, thank you.
And I did run this through the chair as well, as far as she knows that that I was proposing to put this on the.
Yeah.
Judiciary belt.
Mention it to me.
Okay.
Thank you very much.
Thank you very much.
So Director Pelkey, will hear from next.
Yes, good morning.
Good morning, thank you for being here.
My colleague Ashley Fisk, who has 19 years in the Department of Corrections.
We have an expert chair over there. It's all coming together.
So good morning, everybody. My name is Meredith Pelkey, and I'm the Director of Victim Services for the Department of Corrections.
Hi, I'm Julie Fisk. I'm a senior victim service specialist with the Department of Corrections.
And we just want to talk a little bit about what we do. Our little unit is, small but mighty, I always say. There's 1 director, 1 senior victim service specialist, and 4 victim service specialists around the state. So part of what we do is we provide information to victims during the post adjudication process. So that means, we're obligated to give them information on movement of offenders, parole hearings, when a release is coming up. And so it's a lot of movement within the Department of Corrections, which is why we decided that for our post adjudication notifications, we needed to have it automated because we were not meeting those statutory obligations. So, I think I want Ashley to speak a little bit in a minute to when the line system was created and her experience as to why it was created. But so a little bit about other things that we do within the Department of Corrections. It's not just notifications. We also do a lot of release planning with victims. We have restorative justice opportunities. We have a victim offender dialogue program. We also have an apology letter bank that is run by DOC. And a lot of anything a victim really needs in the post adjudication process is what we try to help them with. Ashley, do you want to talk a little bit about Vine history?
Yeah, sure. So, back in 2010, well, actually, it was probably a little bit before 2010. We are statutorily obligated to notify victims of status changes. And so, like Meredith said, those weren't being met. And so, I believe the woman's name was Sherry at the time. She was the director. It was before me, but she was looking into this automated system. So it stands for Victim Information Notification Every Day. It is, there's another system along with Vine that provides victim automated notifications, but Vine is the most used in the country. I think there's only a couple states that it's not in. So Vine, we implement Vine. One of the things that was happening was a big thing around this is victim contact information. So we can't make these notifications unless we have that contact information. And so at the time, the state's attorneys, victim advocates were filling out a form that they were sending to DOC. And so we would get that contact information, and that's how we would reach out to victims. When Vine came into play, there's a front end and a back end. So the front end is called Vine Link, which is what everybody has access to. The back end is called Vine Watch, which is what our staff have access to. That allows us to see who is registered for offenders, how they're classified, so whether they're a direct victim, whether they're an affected party, whether they're an other, however they classify, to see how they want to be registered, so by phone, email, or text. And then we can also see what notifications that they get. We provided the state's attorneys advocates with access to that so that instead of filling out the form and sending it to us, that information would just go into Vine Watch, and then we would take it from there. So even if the victim did not want to register for all notifications, we asked that information, there's a section in Vine where you could put that victim contact information. So even if they didn't want to register, when we got ready for release planning or parole hearings, we could go into Vine and we could find that information and reach out to a victim in that way. And so in the notes section, we would put Meredith Pelkey only wants to be notified of release planning. She didn't want all of the notifications. So that was a way to kind of do a workaround with people that didn't necessarily want to know everything. So at this point, all of our staff have access, our staff had access to it. The state's attorneys, victim advocates have access to the back end. We have a group with
DPS.
Yes, DPS, the sex offender registry, they have access to Vine so that they can get victim contact information and register with them with their system as well. And then Department of Children and Families, we work with them around in their DV and sex assault unit. Yeah, sorry. And so they have access too because we work very closely with them. So what happens is there is a company in Kentucky, APRIS. Their system sweeps our database every 20 minutes. And what happens is booking officers put in booking codes into our offender management system, which then trigger the notifications. So all of these notifications are triggered by booking codes. And stop me if you have any questions. So the booking codes go in. So if someone's going out to court, if someone's coming up for a release, notifications are triggered by those booking codes. And so the system sweeps every 20 minutes, the notifications go out. And so that's the most up-to-date notification and information that a victim can get. With those notifications, there is a section that talks about earned time. And it says, it doesn't say the offender in your case, but it does say that there are some offenders that are eligible to receive earned time. And it talks about how they can find that information either online or they can call us directly and we will look it up. And so that is provided with every notification. Also, our phone number is provided with every notification as well. So we have it set, like it's a good system in place. The big thing though, right now is getting that contact information. DOC has no way of getting any type of contact information. And so what's happening is when it's time for release planning, what we're instructing our staff to do is to check Vine. If it's not in there, they need to reach out to the state's attorney's victim advocate where the crime happened, and then they will provide the victim contact information. And then our staff take that information and call a victim and say, hey, he's up for release. And so that's a little traumatizing for victims because they're being contacted at the kind of end where it would be very helpful if we could get that information at the beginning. So then we could kind of, do like lay down the groundwork, like this is what you can expect from the notifications. This is what you can expect from DOC. But that's the big thing is getting that contact information in there so that we can provide these services for victims.
Angela, then Ian.
So I don't want to venture, I was going to just reread the task force chart. I don't want to ask questions that are really just going to be the work of the task force, I guess, but speaking specifically about the earn time notification, where would you like to be getting that contact information? How would you get it earlier and tell me if I'm veering into task force.
No, I think it's a great question. So if we were able to get the contact information at sentencing, then we would be able to tell the victim what they could expect from DOC. They could tell us how often they want to hear from us. We could tell them about Vine and ask them if they want to be registered in Vine. For post-adjudication notifications. I think it's really important. I just want to highlight, like, this system that was developed, Vine, was for Department of Corrections post-adjudication notifications. So it works with our offender management system. And we're kind of the experts on our system, like the OMS and Vine, and we work together with that piece. So I just want to make sure that's highlighted.
And what we have here, the change to language and statute on for the earn time piece of it is just simply a line that says, provide timely notice, not less frequently than every 90 days to the offender. And the addition is, and to any victim who opts to receive the notice.
Yes.
So how would a victim opt to receive that notice?
They would have to let us know.
They'd have to let DOC know.
Yes. And it's been the reason why I didn't want to invest right now well, first of all, we always want to have those relationships. That's the most important thing. But it hasn't been our experience that victims have called us and said, we want this notification, we want to know every 90 days. Because if a victim did call us, we would give them that information. Right. We would set a reminder. So I just want to make sure that's what victims want and what they need.
Right. How would a victim know that that's an option?
So can I? So before originally Vine, there was an option. There was multiple options for notifications. Nobody was using those. And so we took them away. And so it's now you get all of these notifications for not. However, there have been some concerns about people not wanting to go online. So we've offered those individuals. We've said if there are individuals that don't want to look online every month, to give us a call. We'll put it in our calendar to, reach out to them every month and update them. Because the thing with the earn time every month is that it can be very traumatizing for a victim. And also that earn time goes in manually. So it's really only accurate. It would only be accurate for us to do it every 90 days, no less than 90 days.
But to answer your question, where would they find out about this information? My hope is that this is happening, but I mean, it's been my experience, it's not always happening, but these conversations are supposed to be had way before somebody comes to the Department of Corrections. They're supposed to be told how much earn time somebody could get before, even the plea agreement. So, I think that's where somebody would say to them, if you want to have earn time, if you want to know earn time every month, you have to let the Department of Corrections know. But these conversations should be happening way in advance, like with offenders.
With the essays?
Yes, state's attorney, that's in statute, that
Yeah.
they're supposed to talk about how much earned time somebody could possibly get on a sentence. So hopefully those conversations are being had ahead of time and people are know who they can contact.
Yeah.
The issue is, and I think Jennifer, Director Pullman brings up, is there's no way for these conversations to really be happening. Vine is not used with other systems across the state. Could it be? Yes. But the need of the state's attorneys isn't going to be the same need as Department of Corrections for notifications. So, although I think this is a great way to move forward, I just think that Department of Corrections doesn't know what is going to be needed on the front end with state's attorneys, with law enforcement. And we only know what we know for post adjudication and what we're responsible for. So for us to be the lead on a task force, I'm just not sure we have the totality of what victims really want. And so, we know what we're hearing from victims in the post adjudication process, but we don't really know what victims want in, anything that happens before that. We're just a little piece on the end. So, I did want to bring that point up too.
I guess just to make sure I'm understanding correctly, do you feel that the existing system can support this change, and to any victim who opts to receive the notice? Do you, in your experience, they're aware of victims are aware of the option, and then you have the system to provide the notification?
Well, the system would be, we would do it manually, but if it became too much of a workload, we would look at having a automatic notification.
And part of that, when I said that we took away all those options, we are working on getting them back. But I didn't finish that. Sorry.
Right.
But yes, so we are working, and so that would be an option, would be an earn time notification.
And
So we
those-
could do that.
And those would be for post adjudication notification.
Yeah.
We would give them options if that's what we heard from victims and what victims wanted. But again, we only hear about post adjudication, what victims want. We don't really know. And we don't know how Vine would work with other systems. That's really not, we know how it works with our system because we've been developing it for years with Vine, but it's not going to be the same with other systems that they decide to take and sweep and.
Right.
So to have Department of Corrections again be the lead, we don't have the totality of information.
And I do it as, sorry.
Go ahead.
Our notifications are somewhat generic because Vermont is very different with sentencing, right? So in other states, you get out on parole or you kind of max out your sentence. Whereas Vermont, you can get on probation, parole, or furlough. So we really do need to have those conversations. We want to provide victims with enough information so they know what's kind of going on to keep themselves safe, whether they're in or out. But we do rely on communicating with victims so we can explain that, you know, he's getting a probation sentence. The court kind of dictates that and really explain those little things that victims are not going to get from an automated system. Nor would I want them. I wouldn't want them to. I think that connection is helpful with victims so they can really understand. And then we can provide any added information, you know, like resources. So if they're not getting what they need from DOC, can we, you know, give them information for outside resources too. But we do rely on that conversation.
Ian and then Ken.
So just one quick question on section 31 and then one question on 32. On 31, so very helpful to hear your process. And I think what I'm hearing is kind of how you're complying with the current statute. So I'm curious, should we strike the language, and you guys don't have a copy of this?
I do, I have
Okay.
it.
So A is ensure that the victims of record are notified of the earned time program at its outset and made aware of the option to receive notifications from the department pursuant to the subdivision. So that's like what you were saying, you know, it tells them they can access it online. Also, let us know if you want to be notified. So it sounds like the proposed change to B saying, and any victim who opts to receive the notice every 90 days is sort of like satisfying what that prior, like, let us know what you want. So would it be better for us to strike the language, the second half of A? So it would just read, ensure that all victims of record are notified of earned time program at its outset, strike the option to receive notifications, and then just have B, which says victims can opt in to receive the notice every 90 days.
What page is that on again?
I'm on 25, and I'm looking at line 7, kind of line 6 through
Okay.
12.
I'm sure that.
I think the thing with me would be that it's not an option right now to
No, it isn't, it will be an option to receive notification from us.
oh yeah, okay.
Just so it's clear that basically we're saying, okay, so like the option now is like we're letting defendants know how their earned time is being earned, and we're going to let victims know, and we're going to have them on the same track, as opposed to having like
Yes.
both a 90 days track, but then also another track for victims where they can receive a notification in a different way. I'm not really sure. So I don't know if my question makes sense.
Yes, I think that's right.
Okay. So
Say that one more time.
yeah, so subsection A currently has this kind of vague option for victims to receive notifications from the department. And vague is intentional, I think, because they just sort of like want to let people know that they can get notification when they want it. But we're proposing a much more structured notification system that basically aligns with the offender, that every 90 days they're going to get notified when the offender earns earned time. And so I'm wondering, should we strike the sort of more vague language in subsection A around the option to receive notification, because the option to receive notification is very clearly laid out in the proposed amendment to B.
Who opts? Yeah, because it says who opts to receive. Yeah.
Yeah. So am I making sense, or?
Yeah, although it does say pursuant to the subdivision, maybe it's redundant.
It just seems redundant to me, but
We'll ask other folks,
Okay.
we'll ask legislative council what they think as well.
I just take the point earlier of like trying to make it as clear as possible for people when they're reading it. But okay. And then my only other question was on section 32. So did you say it was APRIS?
Yes.
Okay, so APRIS owns Vines?
Yes.
Okay. And it sounds like maybe a large part of what the task force can be doing is trying to explore how Vines can best, all the options that Vines has and how it can help victim survivors, receive notification and get the information they need. Is there anyone else that we need to add to this task force, either as a member or someone we're going to consult that has expertise in Vines abilities?
Yeah, I mean, I think it's important to have somebody from actually the vendor, right, from APRIS, Also, though, again, we know what APRIS can do with OMS, but we don't know, like, what it can do with other systems in the state. And we have our tech people, but I don't know if it's important to have their tech people.
So
So,
your terminology makes me realize I definitely don't understand this fully. So Vines gets information from OMS,
yes,
but it also gets information from, or it can get information from other sources.
it would have to make other notifications. But that's why I said, I'm not sure, the Department of Corrections
Is the
is the right
okay?
place, because we only do post-adjudication notifications with our offender management system.
Okay.
I mean, Vine can talk to other systems. It does that in many states. It talks to the court system. It could talk to the judicial portal, all the things.
And part of this is trying to get Vines to talk with all of potentially with these other sources.
Yeah, I mean, we would all love a statewide system.
Okay. So, all right, that makes sense. I think we can't compel someone from APRIS to work with this.
No.
No.
Him first, please.
Chair, I was just,
Oh, yeah, identify yourself.
ICO DOC policy director. I mean, I think I just wanted to emphasize Meredith's point that she was making, Director Pelkey, that as it relates to the task force, that DOC is only holding part of the puzzle, right? We are, acting in accordance with our statutory applications for notification, for post adjudication. And I think, some of the recent media reports on this from a student reporter are really focused on the pre-adjudication side of the house. When folks, particularly as their detainees coming in very quickly, leaving, and just kind of, I think as it relates to the task force, that shows that there are a lot of other kind of parties at play. And so the Department of Corrections pays for Vine. That is the system that we pay for, and it meets our needs, but obviously there's other, players in this. So I think it would be perhaps inappropriate for the department to be the lead on the task force, looking, as Mary said, at the totality of victim notification when we were going targeted.
Okay.
So I'm a bit confused. Why is this system so complex? And it seems like victims want to know when the person that did this crime to them, I assume the victims want to know when they're going to be released, correct?
Yes.
Am I wrong there?
No, you're absolutely right.
So as usual, I'm hearing that our systems don't all agree and that they don't transfer information, they don't work together,
Nope.
which totally blows my mind. But the point of the matter is doesn't, and I'm not blaming DLC, I'm just looking for answers.
Yeah.
But when somebody serves good time or they get better time or they could get released early, when they do, when they're sentenced, what's going on. But there's all kinds of adjustments in between time, right?
Yep.
That I think what I'm hearing is you can't keep up to that, or you don't have the information to keep up to that.
So I think it's two things. So if we're talking about when let's say somebody's arrested and, lodged. Okay. Vine could give a victim a notification when someone is released if we have victim contact information. So what's happening is we're getting victim contact information post adjudication. And so this is why if we look at what's the media story, that she was never notified because nobody had her information. Nobody spoke to her about Vine.
Why?
That's a question I think that we all want. I think this is why the task force, is an important piece. But right now, as it stands, DOC does not automatically get victim notification, contact information.
Isn't that a failure of the state?
I don't really know what the issue is, but I feel like, when somebody's lodged, they can be brought to jail by not necessarily the arresting officer. That maybe the information has not been put in Velcor yet. DOC does not have access to Velcor. Vine is not, getting information from Velcor. There's a lot of things that aren't happening. So, I think this is why the task force is important. I mean, I think also we have this working group going to discuss these issues and how we can make sure the victims are getting notifications.
But the victims aren't getting notified.
They're not even, no, they're not even being told about Vine necessarily. We
thought they were. That was our understanding that they were.
we've
told about
delivered Vine, cards around the state to, law enforcement, sheriff's office, as many as we could. We've asked to, do trainings at the academy. We've offered to give trainings to every, state police barracks. So we're trying to get the information out there so that people can give that information to victims. Victims could get a notification if Vine had their information, if they were told about Vine.
So the system isn't working and this is a complete disaster.
The system is
The
working.
system is working.
The system as far as Vine is working, but the system as far as making sure victims are entered into Vine and victims are getting information about Vine, that's an issue, yeah.
Okay, let me rephrase that. One part of the system's working, the rest of it isn't.
Yes.
Representative Goslin, I think that'd be a good question for those who have the jurisdiction, state's attorneys, to talk about.
Yeah.
Victim notification, pre-adjudication.
Yeah.
I'll sit back for now.
So we're going to have more testimony on this, but not today. We have a time-sensitive issue that we need to look at, S28. So we may ask you back if we have more questions that are developing, but we definitely are going to give some time to the Department of State's attorneys, and we'll see if I'm open to understanding from other folks who else we should hear from. Probably the victim's person from the Vermont State Police, since we're going to put that person on here. So we will have additional testimony and dig a little deeper into this.
So can I just ask something? So we're dealing with victims. We've dealt with victims. I've been here 7 years. Victims have never got, as far as I'm concerned, my own opinion, victims have never got a fair shot. We're still kicking the can down the road. Now we're talking about another task force. And I want accountability help, which I'm always asking for around here, which are we going to allow enough time to really deal with this and deal with this situation, or are we going to just kick the can down the road?
We can dig deeper. I don't know that this miscellaneous bill is the bill to accomplish that. I know that there's concern that I've heard raised as far as how we have victim services kind of in different silos, and we need to figure that out. I agree with what you're saying. And we do need to continue to look at that. Maybe it's this bill. This bill we're going to be hanging on to for a while.
Who brought this part of the additions? Thank you.
Yeah, section 3132 was from Jen Pullman, so.
Thank you.
And if I may, the center would be happy to take the lead role. The Department of Corrections does not to that. The task force is going in the direction we would like to represent. This has been a concern of mine for years, and I feel like that report back date, I don't like work groups any more than anybody else, but this one I think is going to accomplish something. I wouldn't have put this out there if I didn't.
May I just ask one more question?
Yeah, go for it.
So you've been asking for this for years and you've gotten nowhere.
I've raised it in terms of testimony and on other issues and building off of what happened in House Corrections and Institutions last session. This is what spurred this conversation. It was just put in the miscellaneous corrections bill. That's why we're here today. So we're getting there. We're taking steps forward, and I believe this will get us.
How many years have you been trying to do this?
I would say I've been raising this issue for several years. Certainly since back when earned time came up, it really was high.
What was that?
2020.
Thank you.
No, we'll definitely have Jen back in as well, and we'll dig a little deeper.
Thank you so much.
Thank you, and we do need a short break, but it has to be very short. We have a number of witnesses. We have a quarter after, we'll start at quarter after.